Hi, today's video focuses on setting aside covenants to allow development to proceed in New South Wales. We're going to talk first about why that might be important. Well, if you purchase a piece of land and you are proposing to carry out development on that land, but then you find out that there's a covenant or some sort of restriction on the title to that land that prevents you from carrying out that development, then you might want to have a look at ways that that covenant may be able to be set aside to allow your particular development to proceed. Now, as always, this is not intended to be legal advice. Please don't take this to be legal advice. Your particular circumstances are going to be individual to you, and you need to get specific legal advice tailored to your unique circumstances. So please don't rely on this as legal advice. All right, now with that out of the way, some of the key things that I'm going to talk about in this video are: one, restrictive covenants can sometimes be set aside to allow development to proceed. Two, the power to set aside a covenant in that way is usually found in clause 1.9a of most local environmental plans and in section 1.20 of the Code SEP. That's the State Environmental Planning Policy Exempt and Complying Development Codes 2008, commonly known as the Code SEP. Finally, the New South Wales Land and Environment Court also has similar powers to set aside covenants under the Land and Environment Court Act. All right, now how do you figure out if there is a covenant on your title that restricts what you're proposing to do? Well, you have a look at the title search, and we'll bring up a title search here and have a look, and you can see in the second schedule there's a dealing number and a covenant, and so you would obtain a search of that dealing and bring up that covenant and read the covenant and see what it says. And here we have we've done that, and we've got a really old covenant, and you can see here in clause B, the covenant says that no more than one main building shall be erected on the land hereby transferred, and such building shall not be used or permitted to be used other than for residential purposes. Okay, so it's doing two things. It's saying not more than one building on the land, one main building, and that one main building can only be used for residential purposes. Okay, so if you were proposing to build a duplex or a medium density dwellings on that land, then this would be a problem, and you'd be looking for ways to set aside this covenant to allow your development to proceed. All right, let's quickly go off on a tangent here. We're not talking about Section 81A of the Real Property Act. So Section 81A of the Real Property Act allows obsolete covenants like fencing covenants, building material covenants, and value of structure covenants to be removed from title. We're not talking about that. That's something different. In very old land titles, there'd be a value of structures covenant that says something like any building that you build on the land must be worth more than £9. And you can go off now to the New South Wales Land Registry Services and ask that that covenant be removed from title. So we're obviously not talking about that in this video today. All right, now LEPs and the Code SEP are not legislation, so there needs to be legislation that allows councils and others to insert these provisions in local environmental plans, etc., to set aside covenants. And that motherhood statement, or that source of power, if you like, is found in section 3.16 of the Environmental Planning and Assessment Act. And section 3.16, I'll read it, subsection 2 there says, for the purpose of enabling development to be carried out in accordance with an environmental planning instrument. So an LEP, a local environmental plan, is a type of environmental planning instrument. Development to be carried out in accordance with an environmental planning instrument or in accordance with the consent granted under this Act. An environmental planning instrument may provide that, to the extent necessary to serve that purpose, a regulatory instrument shall not apply to any such development etc., etc. So what it's doing there is it's allowing an environmental planning instrument, an LEP, to insert a provision that says the covenant does not apply to the extent necessary to allow the development to proceed. And section 3.16 says that that provision can apply to a whole bunch of things: rules, regulations, bylaws, ordinances, proclamations, agreements, covenants, etc., etc. So it's not just limited to restrictive covenants. All right, so that's the source of power that allows LEPs to do this. And let's have a look at what it typically looks like when it's brought into an LEP. But before we do that, actually, let's talk about why this power exists. So why has the legislature done this? Why has the Parliament allowed environmental planning instruments to have these clauses setting aside covenants, etc., and restrictive covenants? Well, Justice Talbot in Challister and Blacktown City Council, it's a 1992 decision, said the opportunity to make such a provision in an environmental planning instrument is intended to achieve a result whereby development which satisfies the criteria laid down by the planning legislation may proceed, notwithstanding any constraint imposed by other regulatory instruments. So it's allowing development which satisfies the criteria usually laid down in an LEP. So if that development satisfies the criteria in the local environmental plan, it's allowing that development to proceed, notwithstanding any other constraint imposed by a regulatory instrument. And why? Well, when you think about it, strategic planners and planners look at an area, a local government area, and they say, okay, that bit over there is going to be for industrial, that bit's going to be for residential, that bit's going to be for recreation. And in the residential area, we think, R2 low density residential, we think that little bit over there should have duplexes as well as single dwellings. So we'll allow single residential dwellings and dual occupancies and maybe medium density in that area. And then you have a developer who carries out a subdivision and stamps a section 88B on there that says no duplexes allowed in this particular subdivision. So you've got a conflict there, and you've got a private developer or a developer seeking to undermine or overwrite what those strategic planners have put in the local environmental plan. And so section 3.16 allows those local environmental plans to say no, our LEP prevails over the section 88B instrument to the extent of any inconsistency. So that's why these powers exist. All right, now what do they look like? Well, clause 1.9a of, I think this is the Shoalhaven local environmental plan, but they're all pretty similar. Suspension of covenants, agreements and instruments, so it's pretty clear what it's about. And one says, for the purpose of enabling development on land in any zone to be carried out in accordance with this plan, or with the consent granted under this Act, any agreement, covenant or other similar instrument that restricts the carrying out of that development does not apply to the extent necessary to serve that purpose. Okay, so where you have an agreement, covenant or other similar instrument that restricts the development, it doesn't apply to the extent to allow that development to proceed. However, you have to be really, really careful, because subsection 2, clause 2 says this clause does not apply to, and there are a whole bunch of circumstances where it doesn't apply. So there are a whole bunch of limitations to clause 1.9a, and you need to be really careful when you're trying to figure out whether clause 1.9a applies to your particular circumstance. All right, so that's in the LEP, and that would apply where the local consent authority, the council, is determining a development application under their LEP. But what about complying development or development under the code set? Well, section 1.20 is, I think it's almost identical to clause 1.9a. And section 1.20 looks the same. Suspension of covenants, agreements and instruments, it sounds the same. Subsection 1 says, for the purpose of enabling development on land in any zone to be carried out in accordance with this policy, any agreement, covenant or other similar instrument that restricts the carrying out of that development does not apply to the extent necessary. So it reads almost identical, I think. And again, similar to 1.9a, there are considerable limitations to when section 1.20 applies. And so you need to, again, be really careful, read through all those limitations and make sure that section 1.20 applies in your particular circumstance. We've been through section 3.16 of the EPA Act, which allows these provisions to be inserted. We've been through clause 1.9a of most LEPs and section 1.20 of the code set. Let's have a look at some case law about when a covenant has been set aside to allow development to proceed. And I just love this case. I don't know why. It's Leonard and Jessica Estates, Pty Limited, 2008. It's a New South Wales Court of Appeal decision. I think I like this case because it's the little guy having a win over the big developer. In Leonard and Jessica Estates was the developer entity and Leonard were the landowners. So Jessica Estates, the developer, carried out a residential subdivision and imposed on those lots a number of restrictions on the parcels of land through a Section 88B instrument. And one of those restrictions in the Section 88B instrument prohibited construction of duplexes on the lots and subdivision of the land for duplexes. And the Leonards bought one of these parcels of land and wanted to build a duplex on the parcel of land. Now, semi-detached duplexes were permissible with consent on the land under the Singleton Local Environmental Plan, which was the relevant LEP. So you've got a conflict here. The Section 88B instrument says no duplexes. The Singleton LEP says duplexes are permissible with consent. In this case, Singleton Council granted consent to a semi-detached duplex and a two-lot strata subdivision on the land, and the Leonards went ahead and constructed a duplex on the site without the consent of Jessica Estates. Now, Jessica Estates took great umbrage at that and claimed that the Leonards were in breach of the Section 88B instrument by building the duplex without first obtaining their written consent. And Jessica Estates sought orders that the Leonards be restrained from further building the duplex, and also that the duplex that had been built ought to be demolished. The Leonards, in contrast, maintained that the restriction in the Section 88B instrument did not apply because the Singleton LEP contained a clause 6.1, which was similar to clause 1.9a that we talked about before, slightly different but reasonably similar, and it said, if any agreement, covenant or similar instrument prohibits a land use allowed by this plan, then it shall not apply to that land use to the extent necessary to allow that land use to occur. So language is a little bit different, but it's essentially doing the same thing, setting aside that covenant to allow the land use for a duplex to occur. Justice Tobias in the Court of Appeal held that the clear intent of Section 6.1 of the Singleton LEP was to permit a land use that was allowed by the Singleton LEP to occur that was otherwise prohibited by the Section 88B instrument. And so in that circumstance, the Singleton LEP prevailed over the Section 88B instrument and the covenant was set aside. The Leonards were ultimately victorious and were allowed to continue building their duplex and carry out the subdivision. So the Leonards had a win. So Leonard and Jessica Estates is a good case to read, and it's authority for the proposition that in some circumstances covenants can be set aside to allow development to proceed. All right, now a quick recap through what we've been talking about. Most LEPs contain a provision empowering a consent authority to set aside a restrictive covenant to the extent necessary to allow development to proceed. The restrictive covenant, it's important to understand, it's not extinguished, it remains on title, but it's set aside to allow the development to proceed, and the consent authority can still take into account the terms of the restrictive covenant when they're determining the development application. The New South Wales Land Environment Court also has considerable powers under the Land Environment Court Act to set aside a restrictive covenant, even a restrictive covenant in favour of council. However, when you're going through Clause 1.9a and Section 1.20 of the Code SEP, it can be quite difficult to figure out whether they apply to your particular circumstances. And so I'd encourage you to obtain competent planning advice to go through the covenant and go through the LEP and to determine whether in your circumstances the relevant clause applies and the covenant can be set aside to allow the development to proceed. If you're interested in this topic, there is a very detailed article on this subject on our website at www.whiteacre.com.au. That article goes into detail of the different provisions and also a number of other cases and case law examining where covenants and other instruments have been set aside to allow development to proceed. So if you're interested, you can visit our website www.whiteacre.com.au. And as always, if you need assistance or planning advice on these or other planning issues, again, you can reach out to us at that website www.whiteacre.com.au. All right, thanks for watching.